Mic test. This is a mic test.
I'd like to bring the Board of Aldermen to order, please.
We'll call to order the Historic Preservation Commission for the special joint workshop meeting with the Board of Aldermen.
If you all would please stand for the Pledge of Allegiance. I would entertain a motion to accept the agenda as it is.
So moved.
The board. The motion and a second. Is there any discussion? Not hearing any. All in favor, please say aye. Any opposed? It's unanimous.
I'll entertain a motion from the Historic Preservation Commission members to approve the agenda presented.
So moved.
We have a motion. Is there a second? We have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries unanimously.
I'm going to ask that the way this is going to work is, and we've already talked about this, is that Chief Drew is going to give an opening statement, and then we'll go from there to questions from the board or any information the HPC wants to present to us. So, sir, if you would start.
Yes, sir. Thank you, Mayor. Good morning, Historic Preservation Commission, Board of Aldermen, citizens. Thank you for this opportunity to have a joint meeting with you. I feel very honored today to sit in this chair position for the last 3 years. An ad hoc committee of the Board of Aldermen completed a Historic Preservation Commission ordinance in September of 2022. They then interviewed and appointed the Historic Preservation Commission at the October 13th meeting of 2022. Since that time, the members of this commission have held nearly 60 public meetings. After many long hours of deliberation and debate, we established rules of procedure, goals, a complete inventory of the proposed historic district in Southport, and drafted design standards and guidelines. These established documents have been reviewed by the Planning Board. We received feedback from the Forestry Committee, the Beautification Committee in adopting these plans, the planning staff, North Carolina State Historic Preservation Office, the city attorney. We've consulted with several times, Stewart Consulting, and many public comments, suggestions, and input from our citizens. All of our meetings have been advertised. We held 2 largely attended public forums that were live streamed in this building, several workshops to address public comments, and to date, over 40 changes, deletions, and recommendations have been completed in the document before you. This commission has been responsive to citizen input. I, as the chairman, have allowed a multiplicity of public input and interaction in each meeting. There are several points that I'd like to make today. Southport has been on the National Historic Registry since 1980. The National Registry is a great program, but it comes with no protection to historic structures in that boundary or guideline or in that district. The comprehensive plan that was presented and voted upon last Thursday night, 600 citizens participated in the surveys. In the top 3 priorities out of 600 citizens, top 3 priority was historic preservation in our city. This speaks volumes. The Board of Aldermen adopted this plan. I want the record to reflect that as a citizen of Southport, I am not for overregulation or far-reaching ordinances. The first draft of the design standards was too restrictive. After this commission's careful review, we noticed that many things that we discussed over the 60 public meetings had been changed by the consultant and had been added into the document. This commission has never had the intention to overburden homeowners in the proposed historic overlay. From the first meetings that we held, it was never our intention to bring to you a document as restrictive or regulatory as Wilmington or Edenton, North Carolina. We have worked to have a balanced document that will preserve our historic character while not regulating the homeowner or causing excessive expenses. This is why we allow the use of alternative materials, metal roofs. We did not regulate things like paint color, doors, roofing materials for alternative uses that other historic preservation commissions in the state do not allow, but we have allowed some of those things to be put in this document because we listen to the citizens. Every public comment we have received has been discussed, and we have woven compromise and the suggestions of homeowners into these standards. It's been said that there are 200 pages of regulations. That is not factual information. The design standards are 108 pages. The standards do not even start until page 45 of the document. The first 45 pages, there is a history of Southport. There are definitions, flow charts, explanations of how certificate of appropriatenesses work. There are pictures, goals, rules, and procedures of a quasi-judicial board. My estimate is there are less than 50 pages of actual standards in the document. The document is well put together. It has pictures and examples to help citizens understand definition of terms so that it's not confusing. This 3-year process has been a great example of the democratic process in local government. Why do we need this overlay and these design standards in Southport? Well, I have a list of 9 different businesses in Southport that are changing right now. We saw the demolition of the car insurance building, the demolition of Ty Pepper's building on East Moore Street. Bullfrog Corner is possibly up for demolition. Recently, Southport Trading, Lantana's, and I don't know the address, but it's on House Street. Miss Helen Moore, if you've lived in Southport, you know where Miss Helen Moore lives or lived. She's passed away. But Southport Trading, Lantana's, and Miss Helen Moore's house recently sold to new owners. Up for sale is Southern Restaurant, Grape and Ale, and Ricky Evans Art Gallery. This is 9 properties in the historic district of our downtown that could drastically change the downtown of Southport forever, depending on what those people that have purchased those properties do. I thought this was very interesting. Since 1997, we have lost 28 historic structures in the 1980 National Registry District. That's just since 1997. That's documented at City Hall for 28 demolition permits. I went back and surveyed because we don't have records from 1997 to 1980, but I looked over the 1980 inventory, and it is my estimate that we have 45 historic structures that have been demolished since 1980 in the National Registry Historic District. That's an average of 1 historic structure per year. It is so gradual that some people have not even noticed it. I call it the erosion of historic Southport. 1 historic structure per year. Gradual erosion of historical character. Elected officials or citizens that have been in Southport less than 10 years. I wish you could have lived here in 1970s and the 1980s. Southport was a different city then. We have lost so much charm and character that will never be brought back. And without this protection, we will lose more. The erosion of historic Southport, as the clock ticks, another property will be sold. Another person will come into town and have a new idea. We lose the character and charm, one structure per year. What will downtown look like in 20 years? In 2045, what will downtown Southport look like? Some of you sitting here will not be here in 20 years. I plan to be here in 20 years if the Lord will allow me to live that long. 25 years, 2050, what will downtown Southport look like? No, I'm not going to fear you to death and make you think that it's going to look like Myrtle Beach, because it never will. But what will it look like if we don't protect our historic character? This commission has done its due diligence. We have tried to fight all the false information out there. We have done our best to dispel rumors. I want my grandchildren to know the Southport that I knew. Now, I realize that change is inevitable. I realize that change is going to happen. I realize we've lost 45 structures since 1980, but let the Board of Aldermen with us realize that we can start preserving, protecting, and preventing demolition now. Southport continues, and we need to make sure that we stop the erosion of the historic Southport. We have to entertain questions today from the Board of Aldermen. I have the documents here of the changes that we've made. If you have questions about those, we have staff present that can assist us in helping us answer questions. But whatever questions you have, this commission is ready to answer, and we're ready to meet you here at the table. So thank you for the time that you've given us to come and talk to you.
Thank you, Charles. At this point, would you agree, sir, that the Board of Aldermen should start asking questions?
Yes, sir. Yes, sir.
All right. Rather than all jump at the mic at the same time, if you would raise your hand, and if you have questions, please let me know. Alderman Kelly?
On page 8 of the introduction, the Secretary of Interior Standards for Rehabilitation, it states on number 2, the historic character of a property will be retained and preserved. The removal of distinctive materials or alteration of features, spaces, and spatial relationships that characterize a property will be avoided. To me, that takes away the ability to go from a 1-story to a 2-story building. Am I reading that correctly?
My answer to that, and Mo, you can chime in, and anybody on the board is free to chime in anytime y'all have anything. My answer to that is, this is going to be a quasi-judicial board. It's going to be a case-by-case basis. Every property is not going to be looked at as the same. Now, we have these guidelines to go by. I can't say, Mo, can you chime in on whether somebody would be able to add a second story? If these
It really is a case-by-case process, and that's how it is built on purpose, so that each case can be looked at by the quasi-judicial board and see if it is congruent with the existing neighborhood. So that is how the process and the system is built, using the standards for congruency.
Right, because the way that I read that, it felt like it couldn't be done. And we've got a few examples in Southport, notwithstanding the property on Atlantic Avenue that Maria and Paul Swenson own, that they went from 1-story to 2-story. That was done beautiful, or actually up to 3. That was done beautifully, and you would never know that it wasn't originally that way. So I have a little bit of concern over that. And then we've said multiple times that this does not control color in any way, but number 6 on the same page says where the severity of deterioration requires replacement of a distinctive feature, the new feature will match the old in design, color, texture, and where possible, materials. So I feel like that probably needs to be struck if we're going to continue forward with this, because we have said no color anywhere.
Rebecca, if I may address your first question about new construction. Well, it would be considered an addition if you put a second story on a first story. In the section dealing with new construction and additions, it does speak specifically about adding a floor. And one example would be, say, if Mr. Pease wanted to put a second story on, because Mr. Pease fronts right on the sidewalk, the recommendation is that the addition be put further back as close to the rear as possible. In other words, not to make a solid two-story front right there on the sidewalk. So woven throughout the guidelines are these suggestions to make things be more congruent with its the building's neighbors. So that's the goal. The goal is not to restrict, is not to say no every time you turn around. It is to ensure, to the extent possible, that that it doesn't change the character of the strip of other buildings it's with, or the neighborhood if it's in the middle of a neighborhood. So,
And on that same page, if you look at number 9, it says new additions, exterior alterations or related new construction will not destroy historic materials, features, and spatial relationships that characterize the property. The new work will be differentiated from the old and will be compatible with historic materials, features, size, scale, and proportion, and massing to project the integrity of the property and its environment. So it does give a place for new additions to be added and new construction to come on, but just to make sure that there's a differentiation between the historic and the new.
May I make a statement? I was trying to find which paragraph you were reading from, and I apologize, it took me a little while to find it, but you're reading from the Secretary of Interior Standards for Rehabilitation. Those are national standards that we included by reference. We did not write those, but if there's a section in the National Register we need to strike, then, that's fine. But I just want to go on record that was referred from the Secretary of Interior.
And I understand and appreciate that, but if this is in our document for Southport, for future going forward, then that's what people will reference, not the fact that it came from somewhere else. They'll reference the fact that it's in our document.
Can I follow up on a couple of things that Kelly brought up? First of all, a case-by-case basis. I don't find that helpful. What are the factors in a case-by-case decision? I mean, what do you bring into consideration? That I know that two houses are not necessarily alike, but what are you looking for to be able to decide yes, this, no, that? Oh, Mo answered, so Mo.
Yes, ma'am. It is up to the applicant to bring the evidence that shows how that their new addition or their new home or changes will be congruent, and then it is up to the board, not staff, to look at the standards and the neighborhood itself to ensure that it is, and the word is congruent. So you just need to make sure that it fits in with that neighborhood, and then it is up to the board, and the board then, or the commission, has the ability to make that decision using the standards as their guidance, but they can say yes or no depending on how it fits in, and it's up to the applicant with the evidence they produce.
Second question, and this is to anybody on the HPC. How do you differentiate between the old and the new? I mean, this is a requirement, but how do you do that? I mean, I'm talking about specific physically, how do you do that?
this is why staff is involved.
Between
It's a process and involves, I'm sorry.
I can address that. Not that I agree with this as it is. Okay, but having worked with architect David Lyles on multiple examples of this, on the interior of a house, if he's taking out a wall or something like that, he actually changes the direction of the wood. So if it's going this way, he'll change that. So certain things like that and the materials used. Not that that's what we're going to end up with or that I would recommend we care that much. But that's one way that he would do it.
Let me ask a question. We said we're going to look at these on a case by case basis. We're going to go through all the facts and whatnot. We're going to make a decision here and make a decision here. Say yes here and no here, then the person that gets a no is going to ask, why not me? All that's going to do is create some controversy. You can't help but do it. You know, I've got a thing I want to do. I can't do it. You let them do it. Why not me?
Mayor, may I speak again? I know I'm sticking my nose out early in this and I
No,
apologize.
the purpose of this meeting is
Okay,
for the Board of Aldermen to ask you questions. We're not actually supposed to be defending or
Okay.
doing anything else except asking questions.
regarding the case by case basis, I served for 3 years on the Board of Adjustment. It's a quasi judicial board. They did it exactly that way. Everything was case by case. People came in to try to give variance for different properties based on hardships for the property. And it was up to the members of the Board of Adjustment to take the facts presented by the applicant to determine whether it was appropriate or not. This is the Historic Preservation Commission is also a quasi judicial board. We're doing exactly the same format that the Board of Adjustment's already doing.
Again,
You're
why
gonna
not
ask-
me?
I think one of the questions that I have gotten probably more than anything is how do you manage the creep? How do you manage going from what we have today with this board who has the right concepts in mind to not ending up like a Wilmington or a Needington? And that's a lot of people are fearful of that. So I don't know if there's a good answer for that, but I think that's something we need to address.
I think to Frank's question and to what he thought, Josh said about Board of Adjustment, there's no precedent in a quasi judicial situation where the individual things are coming before that board. It doesn't create a precedent. So that's that answer. One of the things that I would like to see with 3.1.2, if you go, which to me addresses, no, I'm sorry, this, it's 74 in my book, but I might have a different version because I don't have the markout version. I have the other version. But it's 3.1.2, which I think addresses Rebecca's question, Alderman Kelly's question. And what I would suggest for consideration is a change after the first sentence, because to me, that's the crux of what your question was in regards to how I think about what Paula Maria did. And I would ask that after the first sentence, that the rest of that point be deleted and entered as generally observed the principle of additive massing, where the original structure remains dominant with the additions are adjoining and smaller masses. However, exceptions may be considered. Applicants shall demonstrate to the HPC that an addition with different height, scale, size, and massing from the existing structure is congruous with the historic district. That way, it opens it up to have that conversation. And I don't think, I can 100% tell you, going it forward, no one would not want Paula and Maria's house built the way it is. And so I think this language opens that conversation up differently than that language. I understand everything's case by case, but I think this gives it a more openness. So for me, that was that, and I actually had that vetted by Brady, our city attorney. So anyway, that, and then I actually had another thing, the 3.2.2. So just keep turning. And y'all can, if the commission, I'm sorry, y'all, if y'all have any consternation about anything I'm saying, let me know, please. And then 3.2.7 is to, 3.2.7, where it says applicants will have a heavy burden to demonstrate. I change that applicants shall demonstrate, just make it simpler. Right. Well, just shall demonstrate. That just says, hey, y'all, your application needs to include this information. And there's two other places where that same conversation is, 4.1.1 and 4.2.1, but just changing that language from that burden to shall demonstrate. And so for those 3 points, that's really it for me. Otherwise, as far as things that I would like to see perhaps modified in the standing document.
I know that the things that have been brought to my attention more than anything else is the quasi judicial process. And this is very off-putting and intimidating. Could we get a very clear explanation of what that is and what the process is from the minute you walk into City Hall with an application to the very end of a decision, wherever that might be, court or wherever?
Yeah, Mo.
Yes, so if someone comes in for a major modification that would require a certificate of appropriateness from the Historic Preservation Commission, they will submit an application. The application will outline exactly what each applicant must provide. It will include, site plan, renderings, materials. So there will be a whole list of what they have to provide that will give enough evidence to provide the commission with the ability to take that information and then at the hearing itself, listen to what their evidence is out loud. So staff will prepare a staff report, just like we do for the Board of Adjustment at this time, without any, without looking at or making any decisions upon it, just giving straight facts to the commission itself so that they have the information to take, and they, as the commission themselves, as a board, as one, can come together, listen to the applicant, listen to the facts provided by staff, and then make their decision only on those facts that are provided at the hearing itself. Then once the board goes through, they'll have to give findings of fact why they did or did not approve the changes or the request of the applicant. So that's what they will be able to provide. They cannot just say no and close the book. So there have to be very specific reasonings behind a decision and how it was made. Once that decision is made, yes, we approve this, we grant you your certificate of appropriateness, then the applicant would then be able to come in, get their building permit and move forward, or they would have to appeal it to the courts.
Oh,
And if
go ahead, Robert.
I was going to piggyback on what Mo said real quick. The whole process is listed in this document. It has an introduction that describes the whole process that an applicant would go through. Very well put together. And then it even has the quasi judicial decision that's made, and it states that the commission must use its judgment to come to a conclusion. And then it gives the whole process of the Preservation Commission must take steps reasonably required in the ordinance and or rules of procedure to inform the owners of any property likely to be materially affected by the application, shall give the applicant and such owners an opportunity to be heard. It's just like a court setting. Hold a public hearing concerning the applicant, any major works with the application, and review and act upon all the applications within the reasonable time. So all of the process is listed of what the duties of the commission is, what the requirements of the citizen will be, and then what the requirements of staff is all listed in here. And it even goes through levels of review. What's a minor work, what's a major work, and we've reduced that tremendously through citizen comments and taken out a lot of the things that were already in here.
Maureen, two things. For the group, one thought I had is that you might think about an early review process. By the time someone gets to the point of renderings and things like that, I mean, they've invested a lot of money, so it would be a hardship to get a denial. So just that would be. And then Maureen, can you compare the standard process for getting a building permit for an addition to what hardships this might create, if any, in the process?
Two things. One, I want to kind of mention what you were speaking of prior to if someone coming together with their renderings or their civil drawings. There are in the rules of procedure, there are the opportunity for the applicants to meet with staff for a pre-application meeting so that we can help guide them with outlining what will necessarily be needed for each application, what level of review that they will be having, whether it's a minor or a major application, and whether then it needs to go to the commission itself. If not, it's administratively. And also mentioned by Chair Drew, we have removed a lot of those minor COAs so that would just be more of a maintenance now, and they're outlined in the standards as possible. So the standard process for a building permit, this would be one extra step, yes. It would be no different than someone who would need a special use permit for, let's say you wanted to build a duplex. Right now, you had a single lot, you want to do a duplex, you have to come to the Board of Adjustment, receive a special use permit that shows that this use is appropriate for where it is, and then move forward. And then you would come in and receive your approval or denial from the Board of Adjustment. The approval then you would take to the building offices, you'd get your building permit and move forward, no problem. So it's the same situation.
And
Can
to
there be a
piggyback-
possible,
I'm sorry, go ahead.
oh, I'm sorry. Could there be a possible conflict between the Board of Adjustment, which is quasi judicial, and this board, which is quasi judicial? One of the problems we have with the planning board is occasionally people will zip around to the Board of Adjustment and then come back in that way while the planning board's still working on something. So you got two quasi judicial bodies here. How are they going to be in conflict, or can someone just go to the Board of Adjustment and get a variance and then come back?
It really depends on the project. If it requires something from the Board of Adjustment, I would say would need to go to the Board of Adjustment first to make sure that it's able to happen. If it's an appropriate use, then it would have to go to the Historic Preservation Commission if it was required a major COA.
And to comment on Alderman Carroll's question too, in the document on page 15, there is a pre-application process that discusses about going to city staff for consultation, for conceptual ideas, to discuss different alternatives and to receive information from them. So that's discussed in the document too, that pre-application process to try to help stop any hardships or any cumbersome things.
I guess my question was really, if it's a major COA, staff's not going to be making that decision. So they can guide to the best of their ability, but really this board is going to say yes or no. So as part of that pre-application process, I think a consultation or a conversation with the actual board making the actual decision would be of value.
I think that's an excellent suggestion, Robert. I really do.
As a quasi-judicial board, you cannot have any contact or a review of the product or project until it is presented to you at the hearing. That's how the process is, as quasi-judicial boards are built.
It's evidentiary. The other thing that I think didn't get spoken was that the Board of Adjustment is actually the appeal to any decision. The planning board is not quasi judicial, so that's why those conflicts appear sometimes to arise that way. But the way that this works, they're actually the appeals board.
Would staff give any type of documentation of their opinion at that or pre-application so, okay.
We can only give them the facts. Like, these are the standards you're supposed to be able, that you as the applicant will need to provide proof of how you are congruent, or it meets those standards. We can help as much as we can, but we can't provide them any guidance on what kind of decision that could or would be made by the board.
The planning staff would basically review, Alderman Carroll, the application to ensure the completeness, schedules the application to be heard at the appropriate commission meeting, and provides mailed notification and posted notification about the public meeting to any property owners in the area. Basically, that's their standing in the process.
Can I ask, why is this done as quasi judicial rather than just a regular board like the planning board?
So that's state law. So this process of quasi judicial and all of this is not a Southport invention. This is state statute. So in order to enact the historic district and standards, this is what the law says we have to do. So there's not any way around that because the statute says that.
And does the statute have that quasi judicial going to a board of adjustment in those situations also? Is that also state statute? Okay, I just want to make sure that we're for the appeals process rather than coming before the board of aldermen. You see what I'm saying? Like, I just wanted to make sure that I understood why it goes where.
Other questions? You sure? Because I got 2 pages. If you got others, I want you all to go first.
I have some concerns about this as it stands for the current property owners that have shown over time that they are doing the right thing over and over again. I don't think any of us are concerned with those that are here already. I think that the intention of this is a protection for the properties going forward. I would like to see for consideration that we do this for potentially new builds, whether that's a demolition and then a property being rebuilt in that place, or a property being moved off of a site. So it might not be a demolition to do that, and for major renovations rather than some of the things that fall under the current the minor and major COAs. I'd like to see perhaps the major work at a different point or percentage of work being done to the property, similar to what we see for the camera rules, rather than overarching for everyone who's here right now. I just bring that to everyone's attention and possibility for that.
I'm glad you asked that question, because I talked to the city attorney, because we had heard out in the community 50% as a trigger for initiating a major renovation and that sort of thing. And that by state statute is inconsistent with state statute. State statute, it says after designation, and I'm paraphrasing, and it says after designation of a historic district, no exterior portion of any building or other structure shall be erected, altered, restored, removed, or demolished within the district until after an application for a certificate of appropriateness as to the exterior features has been submitted and approved by the Preservation Commission. State statute doesn't allow just an arbitrary percentage kind of conversation. And that's why this is structured the way it is, that it is mow and jump in at any point. But that's because I was curious about, because one, I couldn't understand how you would do that. And I actually, if I get the indulgence of the board, I actually put together a little slideshow of some case study that I have personally knowledge of to show that kind of thing of how arbitrary that might be. But Brady concurred that that would not be a way to do that. And then just doing new construction where you tore it down and it's just new construction, then that's inconsistent with the whole district. You're singling out that particular property owner for a particular thing rather than it having been a unilateral conversation over the whole district. So like zoning, you don't zone for people, you zone for the properties, right? So the individual person's action is not why you're creating the zoning, you're creating it for the district, for lack of a better way to say
No,
it.
and I understand that, but we do things a little bit differently for a new build versus a renovation as it stands already. And then CAMA's rules for renovation and for us, when you do a renovation up to a certain point, then you've got to bring the entire property up to current standards. I thought that would potentially be an easy way to just grab those, grab those kind of requirements and pull them over for us. But I appreciate you having checked with the attorney for that.
What I have.
I'm a little confused here. I'm a little confused. I thought we were here to talk to them and that they are to defend their document. And I don't see that. I'm seeing that we are acting for them. They are the ones who are supposed to, they've been here, they're the subject matter experts now, and they should be answering all of these questions. This board amongst ourselves can have a different discussion with that, but I'm waiting to see how this board answers all of these questions and why the document is in the state that it is, and for them to defend it or explain to us why things are the way they are. So I'm a little confused right now as how this whole thing's set up. Charles, am I missing the point here, sir?
We'll answer any questions that you have. Yes, sir.
Okay.
I thought this was a workshop where we were collaborative, not putting y'all on the stand and pointing a finger at you. This is the first time that the community's had an opportunity to hear us talk about it, because there's been a lot of BS out there and a lot of headache that if we had done this 3 months ago, might not have existed. So I like this bit of collaboration. I appreciate Rebecca's position. I'm a big fan of your recommendation. We've talked about it several times. So I think that this is more about trying to find how we do this in the best way possible, not to protect Southport from us.
I'd like to address that if I may, your question. One of the things that we can't lose sight of is what the Historic Preservation Commission did earlier before the new recommendations to remove things was the document went to the state historic preservation folks and they approved it. So our job is actually done. You all can change it. We cannot. We can recommend changes, which we've done. That list of 41 changes due to the concerns raised at public hearings. But we can't change the document without historic preservation can't change it without it going back to the state. The changes that you all make, either based on our recommendations or new changes, you can make those and it becomes gospel. We can't do it, you can.
I understand that issue. My question is that if we're asking questions about why should we change something or not change something, I'm expecting you to tell us why that's a good idea or a bad idea, as opposed to Board of Aldermen deciding without your input into this. And I'm hearing very little input from the HPC people, and I want to hear more from you. You guys worked on this for 3 years. I would like to hear more from you as to when questions are asked that you guys answer them, as opposed to the Board of Aldermen answering our own questions.
I've got a question for you guys. Having sat and listened to the conversation for almost 3.5 years, a lot of shit ended up in this document that did not y'all never discussed. So walk us through how that happened, if you don't mind.
Well, I'll comment just a little bit on that. We've talked as a group and we've talked individually, and we feel as though that, when the consultant got the document that, because see, we had already eliminated the landscaping, the tree stuff, we just referred to the tree ordinance because we already have that. So we feel like that's what happened, was the consultant put some things in there that we had already eliminated because we were really trying, the whole time, everybody on this commission has been trying to have a balanced document that would work for the community, because we realized in the beginning of this process that we had to have citizen buy-in or this will never happen. We realized that it has failed 2 times before. So we went into this knowing that. So that's why we've tried to operate the way that we have and include citizen input. So that's what we're thinking, is that some things got added in by the consultant.
Did we pay the consultant the full amount for taking that opportunity to rearrange your document into their liking without your approval?
We didn't hire the consultant. The Historic Preservation Commission, I mean, the city is the one that hired the consultant. Y'all are the ones that signed the contract, not us. So that's a question you'll have to ask of your board and yourself, because y'all are the ones that's done it. Not
No,
me.
we actually, the Bush board never had any input into that decision making. That was a managerial decision and it was skipped. They went beyond, the board was not even consulted. I didn't even know who the consultant was until a week ago, when we were talking about the comprehensive plan, that both the comprehensive plan consultant and this consultant are the same people, which kind of gave me the idea of, well, look at that. No wonder they're mirroring each other. So that.
Well, I think if you look to Alderman Kelly's point, if you look at the input that was obtained in that comp plan, the answers from people actually said those things. It's not just that they happen to be the same consulting firm that made that decision. The answers say that. The answers say that preserving historic charm is important. So, Charles, thanks for being honest. You know, I know that about you, and I appreciate that you just said it, because I never once heard anyone talk about a shrub. Not once. It wasn't of any importance, because that's not what we're trying to do. That was not the intent of the ordinance.
With all the work that's gone into this, and all, we've had several hearings since you guys presented the first document. Lots of things have been changed. We've had a lot of people get up and speak. And of all those people that have gotten up and spoken, unless I'm badly mistaken, everybody has said, I don't want this. I haven't heard one person get up and say, I like it, let's go with it. That concerns me. With all the work you guys have done, which is tremendous amount of work, I commend you for it. Why would we have a situation like that when everybody said, I don't want it, and not have one person, to my knowledge, get up and say, this is a good idea, let's go with it?
I can answer that from my own standpoint, which is,
Lo, how about we let them answer the question first?
I'm sorry.
The question is to the board.
I know
actually-
Miss Pat Kirkman has stood up and said she wants it. So you must not have heard her, Alderman Lay, but she's been at every one of our meetings and she has said she wants it.
You usually hear her.
Yes. But she's not the only one. We've had other people that have come and are supportive of this document as well. But go ahead, Commissioner Greaves.
I was just going to say just about the same thing, Ms. Kirkman, and also there have been other people at meetings, at the Alderman meetings that have spoken and are in support of this. Several.
Flo, go ahead.
Okay, first of all, we three aldermen are the owners of a total of 5 historic homes. My own home is 140 years old. I have another house on North Atlantic that is 120 years old. Robert and Karen each have a house, and I know you went to great pains to try to maintain
No pun intended.
the look and everything just right. And we are in favor of it. But what I was starting to say is, I didn't want this either when I saw the first document. This was an extremely unfortunate initial rollout, and I blame the consultant for that. And I also blame the consultant, and I'm not going to blame you all, but maybe you should have looked a little closer. The second version of it was fraught with errors and included things that by consensus nobody wanted. And by golly, there it was again. I didn't want that, and people really got upset. It looked like an awful lot of things that we don't want anybody to touch were being rammed down our throats. So we now have a final document that I believe needs work, but it's important to know that people got the bit between their teeth because of that first and then the second versions of the document. Many people don't have any idea what this one is. And yeah, they should be here, but they're not. And it's going to be incumbent upon us to really educate the community as to what this is and what it isn't. To further elaborate, as I've listened to lots of people and looked at this, it's clear that there are 2 issues: new construction and renovations. New construction, I don't hear a whole lot of complaints about that. It's the renovation. And there is something inherent in the way all of this is worded and presented that is somewhat insulting, frankly. It's a cumbersome process. Language is unclear. And everything seems to be slated toward no. And I'm a believer in how can we find a way to yes. But people fear that what they have in mind and what they want to do is just going to be rejected out of hand because it doesn't meet someone else's aesthetic. I don't know if any of that's actually correct, but this is the information that's come to me. How do we deal with that? How do we make this something that everybody wants? And I truly believe that everybody in town wants this wonderful Southport to be what it is and not turn into steel and glass structures all along the waterfront and so on. If Hurricane Zelda levels my house or part of it and I have to renovate, my preference would be an adobe structure. I used to live in New Mexico. I love the architecture in Taos and Santa Fe. And so, right now I could do that. I could have anything I want right there. But we are trying really hard to keep things within the historic vernacular that defines Southport. How do we get everybody understanding that this gets us there and keeps us there without insulting them and without making them jump through hoops of fire?
You just did a good job at making steel and glass look good.
If I may, well, I understand that you have some historic homes, so tell me something specific in this document that you find so egregious? Because you have said that you have these historic homes. What is it that is so negative that you just could not follow?
I'm sorry, that I don't like? Oh, I
Just-
like
just
all
tell
of the
me
houses
one
in
thing.
Southport.
No, one thing in this document that's so egregious that you just could not follow, that you just don't like, because you just basically said the document was not worthy.
It's mainly that I don't think it's very clear, and I think that we've got to be better at explaining why this is, first of all, quasi judicial. I know the usual suspect, the state, is to blame for that. But you look at this and it's, what is it, 100 and how many pages?
Now, just tell me one thing that sticks out with you, because you said it's not a worthy document. So one thing that sticks out with you that's so terrible in this document.
That says what?
One thing that is so terrible in this document that you just simply could not follow because you have historic homes. Just name one thing.
Oh, sorry, I find the process cumbersome. And I like the fact that it's not clear that when you want to do something, first of all, you have to get a permit. A lot of people don't realize that. You got to get a permit for a fence. This is shocking news to plenty of people. But you have to, you're going to make many trips to City Hall, this looks like. I'm not saying that this is me. This is what people are telling me they hate about this.
Other comments?
May I speak again?
Of course you can.
Okay, I just want to make sure. I'm back to, I understand people's, resistance to this document. And telling them what they can do and what they can't do. And I understand why that's a big concern. I really do. I just want to go back and revisit for just a second, if I may, Robert Carroll's comment a few minutes ago. And I realized that, we can't have a preliminary meeting with people and rule on something.
Right.
But I do think, in the spirit of being proactive and helping people, I'm an architect, and I've personally met with Mo on several occasions when I was getting ready to do something to a piece of property to see how she felt about it, and, what stupid decisions am I making, just to get a read on it. Proactive is great. And I think that we need to have somehow a panel or a group of people who volunteer, when the first application comes in, to give sort of a preliminary read on it. It's not a definite hard line, yes, you will be approved, no, you won't. But if you give people direction and hear what their concerns are early on, then they're not spinning their wheels needlessly, going through this process with the quasi-judicial board. People need to understand what the rules are and ask questions on a preliminary basis and just say, this is what we think, but you're still going to have to go to the board, and that's what Mo says to me occasionally when we talk about a building permit. We're trying to help the public and we need to do that. Anyway.
I agree with you completely.
Josh, how does staff not fill that role since they are available, as you know firsthand?
Can I say something too? Page 23 in the document is the flow chart. It's very simple. it has a flow chart here that illustrates the necessary steps to go through the process. Owner submits an application to the preservation planner. The planner determines if it's a minor work or a major work. If it's a minor work, you go to the left of the flow chart. If it's a major work, you go to the right of the flow chart. It's not a hard process. I mean, it's right here on one page, a one pager that shows the process. So the process is not cumbersome. If the planner says this is a minor work, you go to the left of the page, projects reviewed by the planner and is approved or referred. If it's approved, the application approved by the preservation planner and a COA is issued, they don't even come to the board. If it's referred, the application is referred to the preservation planner for HPC review. If it's a major work, planning staff mails notices to the adjacent property owners, post public notice regarding the application at City Hall. The applicant appears before the HPC at their public meeting. If it's approved, the HPC issues a COA based on the standards, and the applicant starts work immediately. If it's denied, the applicant can appeal it to the Board of Adjustments based on procedural or substantive grounds. I mean, it's a simple process. I don't see where it's a cumbersome process or a hard process. One page in the document on page 23 shows the whole process for this quasi-judicial board.
How is it that the quasi-judicial HPC decision goes to another quasi-judicial board?
Well, if the HPC denies the application, then the homeowner has the opportunity to take it to the Board of Adjustment for a variance. It's an appeal process.
Appeal of quasi-judicial went directly to Superior Court.
No,
No.
then if the Board of Adjustment denies it, then they have the right to take it to Superior Court.
It almost seems like with being a quasi judicial board that you start off, if you're paranoid, with a hammer over your head. What am I or am I not going to get it? So you're a little bit edgy. So it's almost, if you look at that, it's almost like, from what I'm getting from people I'm hearing from, it's an overreach.
Can you define, I guess I missed part of what you said at first. What exactly is the overreach?
Someone is telling people what they can or cannot do with their property, that we, the board, is going to be able to make a subjective decision as opposed to an objective decision. And I may be hearing it wrong, but that's what I'm hearing.
You know, I thought when I turned 21 that I would never have anybody to tell me what to do. But all my life, somebody's telling me what to do.
Part of what we're dealing with, obviously, is state statute. So if the state preservation folks deem this is the proper way to run a historic district, if you will, then so be it. We have to, that's part of the deal. But we're dealing with design standards. These are, I think, a quasi-judicial process makes it more objective than subjective, and transparent. The only people withstanding, I mean, there's the whole process is predetermined. One of the things I wanted to point out was we started with, just to put this in perspective, we started with 4 pages of a chart with major and minor certificates of appropriateness. We're now down to 7 minor certificates of appropriateness. Doesn't deal with routine maintenance. It deals with very specific changes. Also, all these changes are to the exterior of a home. Nothing steps inside your home. So we're down to 7 minor COAs, and staff can dispose with those in very short order. I believe there's, 2 weeks is tops. There are, I'm sorry, there are 7 COAs, minor COAs, but there's another one, and that's a requirement to renew a previously issued certificate of appropriateness. So the major COAs, there are 9 of them having to do with exterior changes to buildings and 7 having to do with changes to sites and settings. So really the property itself is not the lawn, et cetera. The building itself only has 9 certificates of appropriateness categories. So we've whittled it down to the most important things. There are 6 other certificates of appropriateness, but those deal with new construction or additions and relocations and demolitions. So out of the 106-page document, only 42 of those pages have the standards written out. And I remember one of the initial complaints is there's just so much detail. Well, the point of having all that detail is so that if you want to change one thing, you don't have to go through, you go right to that standard. You don't have to comply with all the other standards. You are only dealing with the 1 or 2 or several standards that affect what your plans are. So it's, if it is overreach, it is not a different overreach than requiring a building permit. And it's significantly less in that case.
And if I could piggyback onto Bonnie, we're only looking at the streetscape. We're not talking about the interior of anybody's house. They can do what they want to. We're talking about the streetscape, what you see when you ride down the street. That's all we're talking about.
Other questions from the
One
board?
other thing, in the process, if it's denied and it goes to the Board of Adjustment, according to this flow chart, if the appeal to the Board of Adjustment is based on procedural or substantive grounds. Explain substantive. To the Board of Adjustment exists to make decisions about uses, special uses, and variances. How are they prepared to make a decision on substantive grounds about historic homes and issues involving changes to, or new construction of historic homes?
Yes, if I may. The Board of Adjustment would not be taking this case on to make a decision on the case again. They would be taking a look at the decision that was made to see if that decision was made properly. And then they would either affirm that decision that was made by the Historic Preservation Commission or reverse it and say, no, we don't see that you have followed the procedure. We are on this side. We reverse that and you will have their COA then. So that they're not looking at the application in the same sense that the HPC would be looking at it.
Then what does substantive, how does that play?
They have to look at the standards and see if they followed the standards in the process outlined in the standards to make sure that that was followed.
Dealt with based on procedure.
They still have to look at the case itself, but they're not making the decision as if they are the Historic Preservation Commission. They're looking at the decision that was made, see if it was followed correctly.
This is one of the things I think is unclear.
If I may, I think that this process is actually a very good check and balance. One of the concerns raised was that during the public hearings, the people stood up and said, we're not worried about you all, we trust. We just don't know anything about the people that are coming after you. So if the Historic Preservation Commission membership changes and you no longer, or it's perceived to be, right now we're perceived to be doing everything, at least our intent is to do everything the correct way, to guard against a future commission not doing things the correct way, the Board of Adjustments appeal is good because it saves time and money. You don't want to have to go to Superior Court if if the Board of Adjustments is going to be a check and a balance on the commission, the Historic Commission members.
Again, that doesn't explain how the Board of Adjustment makes decisions about substantive issues. What are those substantive issues? They're not procedural.
I would imagine if the Historic Preservation Commission members that come after us are bribable, that would be substantive. It is a check and a balance and I think as Mo has explained, they're not rehashing the decision, the deliberations of the commission members.
Let's be very clear. Ambiguous law is unconstitutional. No one in this room has been able to answer Alderman Davis's question on the second half of that. We were able to answer the first part on procedural, that they're only looking to see if this quasi-judicial group followed the book. That's all. But there's a second part of this, and we cannot have ambiguous law because it will be struck down in the courts. We have to be sure of that. Look at the Beaufort, North Carolina cases. It was not, they weren't arguing the fact that you could or could not have a historic district. They argued the implementation of it. And they dragged some guy through the Board of Adjustment, the Superior Court, the Court of Appeals, the District Federal Court, and they lost unanimously on every single point. But the guy who was put through that rigmarole had to put out probably a couple $100,000. And if he didn't have it, he couldn't have gone forward with it. So we cannot have ambiguous law. So if somebody can answer her question, I'd really appreciate it.
I'd like to ask another question. How is this?
No, let's answer one question at a time, okay?
This is related. I don't understand how the Board of Adjustments, which is a quasi-judicial board, doesn't have that same burden.
It doesn't make any difference. We're talking about your document, and your document has to be clear. No ambiguous statements in it that no one understands. Out of this entire room, nobody understands what that is. So I think we have to mark that little part right there and get an answer. Since we don't have it today, we have to get the answer for Alderman Davis.
I'd like to, I want to speak up a little bit. When I came down here today, I swore I wasn't going to say a word. I was just going to sit and listen to everybody. But when I first heard about this committee, this Historic Preservation Committee, and I think Robert and Karen, when they talked to me, the things I personally was interested in is just beautifying the downtown area. I'd love to see some historic district signage. That was my biggest thing I was interested in. Designating the area historic district like Wilmington has, Beaufort has, things like that. I've had the opportunity to go in a lot of towns that have historic districts. Spent some time in Beaufort, South Carolina this past summer, and their historic district, they've got antennas on the roof. They've got everything in there that we would not approve. And I think my personal opinion is, unless you're planning to tear down half your house, none of this even needs to apply to them. Because I've ridden in this historic district. I always bring people, when they come to Southport, one of the first things I like to do is ride people around the golf cart in the historic district. And everybody in here is upset, and they're sitting here wasting their time listening to this thing being nitpicked to death, and they ought to be able to enjoy their life. And because they're doing a great job taking care of their home. They're doing a beautiful job taking care of their home. And unless they're planning on knocking down half of it, none of this should even apply to them. They should be grandfathered in some way or the other. I realize we have to have rules. I realize we have to have some type of rule, but 25 years from now, 50 years from now, like Charles said, Charles is very passionate about this town. I've listened to him for 3 years. He is passionate about this town. I grew up in Charlotte, a city where they tore down all their history. I went to college in a town where they preserved their history. So I've seen both ends of it. I would love to see Southport keep what they've got, but these folks are doing a great job, just like they've been doing for the past 5, 10, 15 years of taking care of their homes. They don't need to be nitpicked over light fixtures, carpet, sidewalks, things like that. They should be able to continue doing what they're doing. And we as a board don't want to put all these undue pressures on them, because if somebody decides, hey, I'm not going to put up this crap, I'm going to go file a lawsuit against you, you're going to get into a lot of financial that I don't think the town wants to get involved in, and it's going to be some bad publicity. So my suggestion is, everybody sitting in here that lives in the historic district, they ought to be able to continue doing what they're doing. They're grandfathered in. And unless they're tearing down half their house, they don't need to come down and talk to this board about anything. And unless you've got an empty lot in the historic district, then you should have some guidelines that you're going to be able to sit, and you need to come to a board and say, hey, here's what I plan to do. Is this okay? That's normal. And but if you would go into some other towns that have historic districts similar to Southport, these other historic districts, they don't look anything as good as ours. These people have fishing boats, they've got satellite dishes, they've got chain link fences, but it's all historic district. It says historic district. So we need to, in my opinion, get back to what I thought we were going to originally do. And that's put up some nice historic district signage, make everybody proud that they live there, and invest some time and money in historic signage, make it look nice, and quit nitpicking this thing to death. It's giving me a migraine, you know?
Where were you at the first part of this meeting? Because you just made a suggestion that we only make it apply to certain circumstances, and we've already answered that. We've already answered that question. It cannot apply to certain circumstances. So you either do it or you don't do it.
Well, I would also like to address, because I'm from Charlotte, I'm from a historic neighborhood in Charlotte, and I will tell you, and I have slides that I wanted to illustrate, because what this does is this is about the future of Southport.
Right.
It is flexible, and it allows for consideration of things. Most of the people I talk to aren't going to be improving their house. Their houses are already renovated and already where they want them to be. So the vast majority of this is going to be affecting new construction or major renovation. But what it will do, if you go to Plaza Midwood in Charlotte, I lived on the side in 1991 that fought to get a historic district on that side. The other side of the neighborhood did not want to do it. And so they didn't. And now, and I've got pictures, I was going to show you the reason why. And the mayor didn't think that that was appropriate for this workshop. But the reason why is that other side now wants to wish they could be historic district. They're so compromised now, 35 years later. So if we don't do this now, 35 years later, then what? Charles already told us how many houses and structures are gone. Elizabeth, I was going to show you pictures from Elizabeth, since you're from Charlotte. You know Elizabeth. Elizabeth in '88 did the National Historic Registry, right? And they never did the historic district. Well, now they're trying to do it. But they have lost, from their 88 listings, they have lost over 25% of the contributing structures since '88. So we either this is for the community, y'all. People say, oh, it's like a HOA. An HOA is for a group of individuals. this is for community. This is us coming together for community, for the benefit of our future and us agreeing. I have a 2-foot, give you an example. I have a 2-foot side setback on my house. So goes me, so goes my neighbor. My neighbor next to me has probably a 2,500 square foot lot. What they do on there, you can bet it's going to affect me. So for us not to create this and come together and work together, and then to have disbelief that in the future it'll be invalid. Oh my God, what will somebody do in the future? Well, in the future, the people will say, oh my God, somebody's doing something and let's fix it. They're not going to allow, it's just like everything. They're not, the board will be a different board, but they'll be paying attention too. So for me, I think that I appreciate, we don't even have a historic district right now. What we have is a national registry listing. So, which is different than the proposed historic district. So when people say you want to designate a historic district, we don't even have one really. What we have is that designation, and that designation is meant to tell us what should be preserved. My house wasn't even included in the listing, and my house was built in 1913. So, and I'm not trying to crank up on it, but what I'm saying is this is about the future of Southport.
I'd also like to admit that I am the world champion nitpicker. One of my favorite activities. Why I am nitpicking on something like the word substantive is I don't want to see this fail because it's unenforceable. And I think that the word substantive is something we got to look at real close as to whether we even want to keep it in here. You know, this board of Aldermen know very well that I sing a song that's called "Don't Pass Ordinances We Can't Enforce." I think this is going to be a problem. I've zeroed in on it, nitpicked it, and I'd like to see it come out.
And Lo, to your question, what I see is the Board of Adjustment would hear the appeal. If the HPC denied somebody and they went to the Board of Adjustment, the Board of Adjustment will judge if the HPC violated procedure or if there is any substance to the rejection or the denial according to the document that we have. Did we have substance to stand on to deny the appeal? That's all it's saying. That's all it's saying. Is there any substance to the denial? Yes or no? The HPC, well, maybe somebody submitted something and the HPC was over-regulating and they denied them. But the document says that they can do what they are wanting to do. And so HPC's upset with the people because they're wanting to demolish a structure and they denied them. They appeal it to the Board of Adjustment. Board of Adjustment says, well, there is substance. They can do what they wanted to do, and y'all ruled the wrong way. And I think that's the decision that they would make. Is there substance to the denial or not? I think it's very simple.
I would like to stick my neck out here. I've already done it several times today, so I'm going to keep on the same trend. To answer Mayor Alt's question and your question, and to follow up, tag on to what Bonnie Bray said earlier, we are a board of volunteer members, and we have volunteered a hell of a lot of time over the last 3 years trying to put this thing together. We developed an initial draft. Then a state consultant was come in to make sure that what we submitted was going to be acceptable to the SHPO office. We've been through a lot, and everybody who's been involved in this process knows that. We're at the point where we have put this document together, and I would like for the Board of Aldermen to give us a list of what is ambiguous in there that we need to take out. I would like for you guys to have a little bit of skin in this and tell us what paragraphs need to be revised. You know, review our document, because I'm, you know, I think that's part of your role. I do. And that may be an unpopular statement, but I think you should take a look at it and tell us.
No, I would agree with you. That's part of our role. That's why we're here. To give you that information.
Well, give us a
It's
list or
it's oral-
something.
It's oral right now, and so if I'm interpreting your statement correctly, you would like a written document that says these are our concerns. Would that be?
Yes,
Where
sir.
you're going, sir?
Yes, sir.
Okay.
You all couldn't just take it the way it is now we've already recommended 41 changes. And, you know, we can obviously add to it, go back to us, but we can't make those changes. You can. So even the 41, we're recommending them, but we're not making them.
Well, the issue that we have here is that we may have an idea that we want something changed. I would like you to have opine on that idea as to why it is either good or bad. So I understand that eventually it comes back to us to make the final decision, but I would have to turn to you guys. You've been the one sitting in the chairs for 3 years. Why is this recommendation from Rich Alt good or bad from your point of view?
Right. And if we can take that on a point by point basis, then we can respond on a point by point basis. Yeah.
Rebecca Kelly?
So if we're going through then, on page 17, we're looking at the City of Southport Local Historic District Review. And I may have missed it, so please correct me if I'm wrong. We continuously say we're talking about the streetscape. We're talking about only what you can see from the street. But when we look at the major and minor COAs, in some cases, you say, it's, for example, under site and setting, you see just changes to significant site features, major COA. Alteration, construction, removal of stone or brick terraces, water features, berms, and ground moving activities, major COA. Now, if you go through this, in theory, that is only what you would see from the street. However, if you continue on to, where is it? Proposed work on page, I guess it's page 18 of the introduction. It says alteration, removal of existing windows, sash, window, opening or trim on, installation of new windows on front and visible side elevations, alteration, removal, installation of doors, opening, trim. So in one section, it actually names the front and visible side elevations. On the others, it doesn't. So that, to me, that becomes ambiguous, because are we talking about then only for that particular one, what is visible from the street, and all others are then wrapped around the home?
I think that addresses corner lots.
But then we're only doing the installation of new windows on front and side visible and new sides on front and visible side elevations, but all of the other things are only for the front, or it doesn't actually name just the front. So it could be, again, not by this board, but in the future applied to the entire home. Because from my backyard, I can see their back door. So they should have to do their back door because I can see it from my yard. You see what I'm saying? Like that kind of thing becomes an issue.
Why are we even getting into sidewalks, parking lots, and driveways? Last one before exterior changes.
Addition and installation of sidewalks, parking lots, and driveways.
These things are dealt with in the UDO. Why is this in the HPC document? I mean, this is the kind of thing that, you know, makes people grit their teeth and say, this is just overreach.
Can you explain why you kept any of the minor COAs? That was directed at the HPC.
Well, I mean, I can go down the list. installation of window air conditioning units and window fans. That's a minor COA only if it's a permanent installation. Somebody's going to permanently install that. So we figured that to do that, if it was, because if it's an emergency situation, they don't have to apply for a minor COA. But any minor COA, just staff handles that. It doesn't come to us. But we figured a permanent window air conditioning unit in the front window of somebody's house in the historic district kind of be unsightly and deter the historic character. That's one reason. Alteration and removal of signs. That's a hot topic in the historic district. That's why we left that one in. Alteration, construction, removal of service and utility chimneys. Most of them have standing with historic character is the reason that we left them in.
Give me just a second. I'm trying to find an answer to your question.
Whose question are you looking for an answer to,
I'm trying
Josh?
to, Lowe's question about the sidewalks and parking and all that.
I remember we discussed it.
It's buried in here and I'm
I
trying to
can't
find it.
remember exactly the reason why we addressed that. I think if I remember correctly, it's basically for the commercial district in the historic district, but I can't remember exactly why we left that in.
But wouldn't it be in the UDO?
As
Redundant.
with the signs.
Oh, I will say about signs, since you said that in the discussion, in the last update on signs and the discussion in the planning board, if you look through the minutes, they talk about you having the HPC review signs for the historic district. So that the planning board was counting on them doing that because they're unique.
But it also says.
Over on page 48, Low, it talks about standards for driveways and off-street parking. And it says specifically locate new parking lots and driveways in the historic district as unobtrusively as possible. Parking lots consisting of large expanses of concrete or asphalt with little planting or other screening are not appropriate. And I think that everybody in here would agree that if you have a property in the historic district, you don't want to pave the front yard, basically, unless you do something with screening. And so that, I think that's the reason that's put in there.
And I certainly agree with you, but it's already in the UDO.
Yes, it is in the UDO.
You can't concrete your front yard. We just passed that one. And, the appearance of the driveways are in the right of way, and within the right of way ordinance, there's the dimensions, the materials and so forth for driveways. So this is, I think, redundant and becomes part of this. It creates this impression of overreach.
And it's just another layer of protection, honestly, and it's all about look and character. But this is the deal. When you go to vote on this, you can remove any of this that you want to remove. I mean, if you decide that you don't want the HPC to consider sidewalks, signs, that can be part of your motion. Just remove it.
Yeah.
Other questions?
One more point about that. Our intention was not to be redundant and our intention was to be clear and to not include things that were in the UDO. So if you all determine that this particular UDO text says the same thing, then it just can be stricken. The point is to provide an extra layer of protection when it's necessary. If it's not necessary, then it doesn't need to be in there.
And another thing to consider when somebody's making an application, you know, they're not necessarily going to read the UDO. If somebody comes in to, you know, build something on their property, they want to know what the Historic Preservation Commission is going to say. And so we can take it out, you know, it's redundant, but, you know, and I'm sure that planning staff will remind them that they can't do certain things in the front yard. So
I'm actually not opposed to leaving it in. That's just my one opinion because you're correct. If I have to look at the 14 documents to figure out what I can do, it makes it more cumbersome. As long as the words that are in here mirror the words of the UDO, then for my personal opinion, I'm good with that part. Other questions? All right. So this started 3 years ago. The world was X 3 years ago. The world is Y now. Didn't make any difference whether we like it, don't like it. It's what it is. So I'm going to ask the HPC board these questions. These are things that were raised to me. Some of them I actually already know the answer to, but since they've been raised and there's a question about them, I want them on the record to say that you guys have answered them. Okay. And I did in fact vote in the beginning to have this group put together and to give us some recommendations. So it may sound like I never had anything to do with this when I start reading this, but I want to put that right up front. Yes, I did vote to have this go forward. So I'm listening to the words here, and I'm going to start off with just this quasi-judicial thing. I don't find in this document, and maybe I dismissed it. I'm not saying it's not there. I don't see the definition. If the board votes on something, on the very next day, this quasi-judicial group has to be up and running. The very next day, because somebody might come just walking through the door and want something done, and we said this is where you go, and it's not there. So I have a couple of questions on the quasi-judicial group. We have no recommendation about the number of people that are in it. We have no recommendation about the qualifications for being on it. We have in the past, and as recently as last night, talked about, you know, if I like you, I'm going to put you on the panel without any qualifications whatsoever because I like you. Well, I'm not sure that's where we need to be with something that is as critical of an event as this is. You're talking about people's properties. So somewhere along the line, we have to kind of figure out how many people are going to be on this and what qualifications they should have other than I just like you. Yes, ma'am.
Sir, if I may, please, this is all outlined in the city ordinance. When the historic preservation ordinance was approved in September, the commission was created at that time, outlines the number of members of the commission, which is the quasi-judicial group. So your commission sitting here is the quasi-judicial group.
Well, that's what I was picking up by the answer to that, but I'm not sure I'm good with that. One group was put together to put up the document together, and now they're already being absorbed into this thing. I understand what you're telling me, that that's how it is written now, but with the stroke of a pen, that can change. So that's a concern that people have, like what the qualifications would be. So I'm only bringing these up so we can get that out in the air. An ordinance is a document made by man. It can be changed by man tomorrow, okay? It's not made by God. There's no really discussion in this whole document or analysis about how many more staff members we're going to have to actually hire to administrate this whole thing. I don't know if anybody thought about that, but it appears to me that there's going to be a lot of work to be done here. And I'm not sure that the current staff numbers are there to accommodate that. So I bring that up as a.
Can I answer that? Because
Yes,
I think that's already been addressed by previous city manager and another administration, Ms. Tysinger is our historic planner. And I think that that was the only position that was, she does a dual role. She does historic planner and permit tech. And I think that that covers everything for staff. And I see Mo nodding her head, so
Okay,
that was, I believe that
that's
was.
why we're bringing this up, to make sure that we have answers to those questions. Has homeowners insurance been discussed with this group? So this past week, outside of the 3 years, but it has been raised to me that, and I then called the person giving the opinion, the insurance guy, to ask questions about that, because I'm not familiar with it. But it appears that once you start going into the historic designation part of a house, the number that I was given is 90% of the insurance companies won't insure you. That was what I was told, 90%. And if you do get insurance, you're not going to get the preferred, you're going to have not a preferred rate given to you because of the difficulties of reconstructing the house with the same materials or close to the same materials in the same manner, because the insurance companies always want to give you less money for that. I bring this up only for discussion purposes because I don't know if that's the right answer or the wrong answer, but I'm merely asking you, has that topic been discussed?
It's not been discussed as a group with our commission, but I have discussed it individually, because I did get an email on it. And I've discussed it with some of the Board of Aldermen members individually that have checked into it. Alderman Davis, I believe, checked into this. And I don't think that that's factual information. And if she could speak on that, because I would just like for her to give the history of, but she contacted her insurance company.
Well, and I'm certainly not going to tell Alderman Davis she can't talk, but she has one subject matter expert, and I talked to another one, and they're at odds with each other. And certainly go forward.
You go first and then.
I'm going to talk as if I know what I'm talking about. I don't. I'm not an insurance broker, but I did call mine. And she also is the insurance broker for my daughter's house. My daughter lives on West, and she lives in the second oldest house on in Southport. And she gets insurance. It's fine. It is not classic homeowners insurance because of the age of the house. Historic has nothing to do with it. Historic is not a term that insurance companies even use. They're looking at the age of the house, and then they're looking at, do you have a new roof? Do you have new plumbing? Do you have new electric? The foundation. You know, it's the condition and the age of the house that determine, first of all, whether they will insure it, and then what kind of insurance you can get. We who have houses older than 50 years can't get classic homeowners insurance, an original recipe homeowners insurance. We get dwelling insurance. It is a way, you're taking two routes to get to the same thing. You're insuring your property. And so she said that there's not anything to worry about with a historic district. You may think so. I asked her if this made a difference, the age of the house and so on made a difference in the premium. And she said, of course it does. Yeah, it costs more to insure 140 or a 200-year-old house than it does to insure a new build. There's also the wonderful factors of how close are you to a flood zone? How close are you to the water? How close are you to a fire hydrant? Things like that. But the historic district per se and whether your house is designated as a historic landmark or not has no bearing on whether you can get insurance.
So that's right now. It depends on the age of your house. It doesn't have any standing on if a district or overlay is imposed.
Yeah, that's correct. And I carry about 3 policies just to get a standard HO3 coverage.
And this may answer the mayor's question. It's only certain carriers that will insure older homes. So I don't know that 90% conversation. I don't know who that came from, but when I talked to my nationwide agent here, that's what she said, is that it certainly, and you were getting into functional age, but it has to do with only certain ones will carry older homes. But that's because we own an older home, having nothing to do with a historic district.
I think just commenting on that a little bit further, that as many historic districts as we have in the state of North Carolina, that would be a major issue if they couldn't get insurance. And
I don't think it's they can't get insurance. I just don't know the cost. So one of my idiosyncrasies of many of my I have many idiosyncrasies, is that I try to look at risk management, not risk elimination. We're not in the business of risk elimination, but it's an issue that as recently as 24 hours ago was brought to my attention and reaffirmed by one source. I don't want us to do anything that's going to cause the city of Southport to be financially liable for something. So I'd like somebody, you guys, it's in your court now, to see if, other than I pick my guy and you pick your guy, there's got to be somebody who's subject matter expert in this and can give us an overall view. And whatever that is, I'm good with it.
I would suggest that Mo contact the State Historic Preservation Office in Raleigh and have them to give us a statement on it. That would be my suggestion.
I would ask the insurance industry, not the historic preservation.
Well, I know
Yes,
the insurance commissioner. I know the insurance commissioner very well. I can contact him.
I think that would
Mike
be
Causey.
wonderful to
We deal
hear
with
from.
him. We deal with him all the time at the fire department.
That would be
I can call Mike Causey's
that would be a
office
terrific,
and get a.
good thing to be able to check off that box then. I have, in the world of changing worlds, we have the elephant in the room of Senate Bill 282. Senate Bill 282, the downzoning bill. Have you guys looked at that? Not just you guys look at that, but do we have a legal opinion whether or not 282 now supersedes whatever SHPA thought they were doing in the past, supersedes that regulation? Just telling me that it went to SHPA doesn't give me a warm and fuzzy, because I'm not sure if they're aware of Senate Bill 282. So, yes, sir.
I don't know the number. I wrote an email about this a couple times, but it is in the general state statutes that historic preservation commissions are allowed, and nothing in 252 changed that. It did not. It didn't change, override a previous statute.
Well, I'm not sure that that is accurate, not because you're trying to deceive me, but because they may have, it's an unintended consequence of 282 to say no more downzoning, and they weren't even thinking about this. But there's one bill supersede the other by accident. That happens all the time. So I think we need to have an opinion on whether or not 282, the downzoning part of it, supersedes the way the state's been operating for years. We have to have that decision before we can make any decision.
We've discussed Senate Bill 282 at several meetings, and we did get a ruling from the city attorney that historic preservation is not downzoning.
Okay. the question is you've drawn borders, because you had to draw borders. If a house that's less than 50 years old is within those borders, does all of these standards apply to that?
No,
They don't.
no.
Okay. I want to make sure that we've said these words and we've looked at that issue. And so that if my house is only 25 years old, but I happen to be in that configuration, I'm not going to be.
Well, Mo, correct me if I'm wrong, but my understanding is unless the house is 50 years of age or older, it does not fall within that category.
All properties within the district would have to follow the standards. That would just be if it's considered a contributing property if it's over 50 with the architecture, but if it's within the district itself, all properties within that district would have to follow the standards.
All houses, regardless if it's 25 years or 50 years.
Correct.
So that
that?
is the kind of a big thing, because even with 50 years, because I'm an old person, that means 1975. And many houses built in 1975 were not built by Frank Lloyd Wright. Captain Ahab didn't live in them. Bunch of guys got together, built a cottage. Really no significance to the cottage. But it doesn't make, that argument doesn't make any difference anymore, because regardless if it's 50 or 15, if I'm in that district, these all apply to me. I want to make sure we're all out on the playing field with that. Okay, the two biggest ones that I
Can
have
I
here.
ask a question that's a follow-up of that?
Yes, ma'am.
In the inventory, how many houses, how many structures in the historic district are less than 50 years old?
Have that information, Mo?
I can get it. I don't have it off the top of my head.
Okay, but there's some. So regardless if it's 1 or 100, it's somebody's going to be impacted by it.
But it's non-contributing. It would be a non-contributing structure. So I think how these guidelines are applied is something different. It's not like a 100-year-old house has got the same conversation. I mean, the guidelines are the same, but it would be in context of the 50-year-old house, right?
I'm sorry, I'm confused. If the standards are the standards, I'm not sure what the first part of your conversation is. I apologize for that.
That it would be congruous with the 50-year-old house. It wouldn't be congruous with the 100-year-old house. Would that not be?
Well, I'm talking about the 25-year-old house.
Or the 25-year-old house?
Yeah, so
Is
the
that?
standards are the standards. They don't change regardless of the age of the house now, correct?
The standards are not ordinance, and it doesn't, so if someone comes in with a home that is 5 years old, they're going to renovate it, or someone buys a 5-year-old house and wants to renovate it. They're looking at that house and what the changes to that house in relationship to the neighborhood are looking at. They're not going to say, well, you've got to turn this house historic because these standards say these. Is what you're doing congruent with the neighborhood, with your home itself, not per some older home that has different architectural features or characters.
Okay, so I'm going to move on to the next topic, which is, I'm going to read a paragraph. And I took this out of this book here on page 85. A COA authorizing demolition of a structure in the historic district cannot be denied unless the building is determined to have statewide significance, which is generally defined as being individual eligible for the National Register or historic places with significance at the state or national level. Then the commission may deny the COA. However, regardless of the determination of significance, the HPC can delay demolition for up to 365 days to all for a study of potential alternatives. I'm trying to figure out, does that paragraph mean that unless the house is on the National Register or Historic Places document, that I come in, I want to knock the house down. I get told I can't do it. The clock starts 366 days later. I walk in and I knock the house down. I'm good to go. Is that what that says? It does say that. Okay.
Yes, sir, it does.
All right. So
We can't prevent you from demolishing your house, but we can just delay it 365 days trying to talk you out of it, pretty much.
Exactly.
Well, you can work with them, but if I'm determined to knock it down, I'm determined to knock it down. I came here and I had in my mind, I'm going to knock it down. So all of this doesn't prevent the house from being knocked down.
No.
Okay.
It
I
can
just-
still be demolished.
The overall thing is that one can still knock it down. Now, this question is for the HPC people. In my deliberations, should I take into consideration that 196 lot owners out of a total of 253 residential lots in the district, that's 76% of the lot owners have asked for this not to go forward? Should I take that into consideration? Up to you guys. Yep.
True.
Or any one of you.
Well, I'll definitely answer it. Earlier, Alderman Lay said that everybody that's come to him said that they do not want this, that they're completely against it. And I was going to say then, and I was hoping to get by without having to say this because I know it's going to make some people mad. I've had people that signed the petition that come to me and told me that they were harassed to sign it, that they signed it because they didn't want to be at odds with their neighbors. A 90-year-old lady that lives on Rhett Street was told that if she did not sign it, her taxes were going to increase, and that's why she signed it. So the petition was presented to the Board of Aldermen. You have to certify the petition, and you have to do what you feel is your responsibility to do that. It's not for us to say whether the petition is valid or not valid. I mean, that's a determination. I think the petition went to y'all. It didn't come to us. You're going to be the ones that's going to have to make a determination on that petition. And that's my answer.
Well, also, that petition got started and got legs real quick in response to the first document, which had things in it that nobody wants. And this is what many people in town still seem to be thinking is what we are considering. Whereas we are, what is it now, 41 things have been taken out. I mean, this is a whole different animal here.
I think that just to that point, Lo, I believe that as it relates to that first document, I think all three of us would have gladly signed that petition as it related to that first document. And we tried to say that many, many times, but it was fought with determination.
So I'm trying to think of how to put this in the right words. We have maybe some people, we don't know how many people out of 196 people have decided that they were intimidated into doing this or bullying into doing this. I would agree with Charles that the city has an obligation to follow up with these people and ask them today how they feel, because every petition that I've ever heard of in any jurisdiction has to have some validation to it.
Sure. It has to be certified. I mean, normally in years past, the city clerk would have to certify the petition when it's presented to the Board of Aldermen, is what I've seen historically. And I mean, it's not for me to certify it or to say what validity it has.
But the other thing that I think is important is that we're still not there. So we're going to have another petition for a document that's not complete.
Exactly.
Well, we can try to figure out how the wording, but at some point in time, I'm going to be asking the Board of Aldermen to work with the manager and the clerk to figure out what the process would be to validate the petition. And so rather than try to demonstrate or to definitively say today that it's going to be on today's notice, I don't know if that's the correct method or not, but I do know that the people that signed this petition at any time could have gone and withdrawn their name if they wanted to. There was, I don't know, I've never heard anybody saying they were prevented from doing that as these phases went through.
And can I add, Mayor, you know, I'm just speaking on behalf of the commission. This commission has compromised. I mean, we've taken stuff out of this document that I did not want to take out. That is going to affect the character of Southport, but we've taken things out. We have compromised. But some of the folks that have come to us, there is no compromise with them. They're just saying, we just don't want this, period. We don't want this at all. You know, we've got to come, you know, I think about the child story, Mexicali soup. Has anybody ever heard that or read it? You know, the mother has a large family and she's going to make a big pot of soup. And granddaddy says, I don't like onions. And grandmama says, I don't like potatoes. And her husband says, I don't like green beans. And her son says, I don't like green peas. And the daughter says, and I don't like salt and pepper. And the other cousin says, I don't like this. So when they sit down to eat, mama puts a pot of boiling water on the table. That's what she's got. And the story, the moral of the story is, you know, it's about community and it's about shaping and compromise. And this commission's done our due diligence. We've changed 41 things. We've listened to the citizens. But can Ms. Lopolis back there shaking her head? No. Can we get some compromise from you? No. You're sitting back there shaking your head no. Because you don't want any, it's just Dr. Sheets. He doesn't want any compromise. I mean, he just absolutely doesn't want anything. So do we just have a pot of boiling water? Or are we going to come to the middle in the community and we're going to say, we got to do something?
I think that what they do want is protections, because as soon as a concrete box is built next door, you know, that we don't want that. Nobody wants that. I think every single one of us can agree. We don't want to see things torn down to build that. What we do want to see, if something is torn down, we want to see Bonner Herring's house. That's what we want to see. And the pile of that was there before needed to be torn down.
And we want to see Dr. Sheets' house and Miss Lopley's house because they're perfect and they fit.
And I can't think of anything that either of them would do to their home that wouldn't be in keeping.
So refresh my memory, because we may have already said that we can't legally do this. I've lost count. I'm playing off what Tal had talked about. Is that, could this all be boiled down to what triggers anything for the first phase of trying to get something? While, Charles, you're absolutely correct. There are some people who don't want anything. But that's the number of people that I've talked to, that's not their stance, okay? They want something, but they don't want necessarily this. So is there a mechanism to do in a first phase of this that says if you take down X percentage of your house, the outside of the house, the standards kick in? And other than that, in my head, maybe I'm looking at it totally different. That would eliminate almost everybody who's already done their house and fixed their house and done their house. It would also, if their heirs would fall prey to that, everybody would fall. It would go down the chain of inheritance and everything else. But if you took so much down, it kicks in. Otherwise, we're going to leave everybody else alone. I don't know, I'm not smart enough, and I want the help from you guys to be able to figure out why is that inherently a bad thing to do, to get the ball rolling, to stop our collective fear. Yours and mine. You and I have talked about this in private and in public, about our fear that either one or more houses could be bought up and knocked down and the style change. That, what I was just talking about, would prevent that. And then it would relieve everybody else of those issues that they're concerned about, I'm going to use the terminology that people are giving, the nitpicking part of it. Now, I'm sure that you wouldn't agree with that language, and I don't necessarily agree with that language, but that's the language. So I'm kind of looking for some help here. The other part is that I have to admit, Mo, that I missed the point. My bad. That the quasi-judicial group would be this group right here. I missed that. I thought when these people are appointed, they're appointed to do this document alone. And I'm concerned about that because most of these people don't live in the historic district. And that was not given much of a thought when we picked the people.
Well, there was no district. There still is no district. So how can we write ordinance for a district that doesn't exist? So that's the start on.
Within the boundaries of the area that we're.
There was no boundary. They looked at every single property and they determined what side of the street they'd cut that boundary off or not. So first, that's why the ordinance was written that way. Second, we have a recommendation from this group to increase the number of members that live within the district. But again, there is no district.
And that said, 3 of the people that were appointed lived in what was the registry listing area. Outside, 3 other people lived right at the edge of it. Joanne lives right there at it. Alexa is living in a house, a historic home right outside of it. And I can't remember anyway, but that's over half of it. Over half of them were generally there. And in the ordinance, the thing that Mo didn't read is in the ordinance, it talked about skills and sets. And so these people weren't just arbitrarily picked. They were picked for reasons that what they brought to the table. And I'm in agreement that once we establish an actual historic district, then we will want to specify membership on the commission defined by being in the historic district. But we didn't really have one. And like I said, 5 or 6 of them were essentially there, but everybody was really picked for what they brought to the table. So I agree that we modify the ordinance, but we got to have a historic district to do that.
I agree with it also.
And also, going back to the history of this, when we sought applications to be on the HPC, we got 22 applications. 2 people withdrew before we were doing interviews. And out of the remaining 20, I believe 3 lived in the district. And there was a lot of interest in this and a lot of conversation and publicity about it. And we still didn't draw that much interest from people in the historic, what would become pretty obviously the historic district. I don't like to suppose that people are unwilling to vote wisely and impartially, and saying that only people who live in the district should be making the decision implies that people outside the district would be more willing, would be looser and not want, would want stricter rules than people who live in the district. I mean, this is a whole town. We don't go for people who live in certain areas, for the planning board, the board of adjustment, the parks and recreation. I'm sorry.
So just the board of aldermen.
So,
No.
Lo, I'm just going to say that if we get to that point, if we do establish the district and we get to a point about the makeup of that board, I am absolutely in favor with the recommendation that the majority of the members be from within the district. I think that the effect that it has on them is greater than the effect it has on someone that lives in St. James, or excuse me, River Miss, St. James certainly, but River Miss, outside of what we would consider that historic core. So, I don't know where you were going with that, but
By not having enough people.
we have plenty of people willing to
You
participate.
made those decisions rightfully 3 years ago. You made those decisions rightfully 3 years ago. The world has changed. Now they have a document. Now I would tend to think that if you were to have a quasi-judicial selection process, you would have more than 3 people that live in the area in the district apply for it. So I go back to my original statement. The very next day, if this is passed, all of that has to have already been worked out. And we have not worked that out. No, but before we can pass anything, we have to have the entire game plan in front of us. Otherwise, we're being disingenuous to the citizens that are going to be impacted, that we're going to vote on something, or you're going to vote on something, and that we don't know what this whole quasi-judicial group are going to, what skills we want, we should be looking at trying to figure out that as best we can.
Yeah, some of that is defined in the ordinance. And so one of the things, Maureen, that might make sense is, could we adopt the district without the standards? And then that would, no. Okay. One of the questions I have is, how do we form the change to the ordinance requiring those members if we don't have the district?
You could stay the ordinance. So if let's, for example, say we pass the ordinance today, just as a date, you could stay implementation of that ordinance for a month, whatever the date is, to then change the ordinance to the membership that you want to go through that interview and appointment process before the board actually sets again. So just like any ordinance, we have an effective date. A lot of times it's the date of adoption, but you can always have a date of adoption later on.
And then I may have missed this somewhere, in the makeup of that, I would like to see business owners that are in the commercial business districts in that makeup as well, because otherwise that is left out of that conversation.
I'm still going to go back to remind everybody that as of today, we have 76% of the lot owners saying not to do this. Now we're going to go back with the clerk, who has to validate the whole thing. Okay.
There is no certification process. It is these folks have signed their names, so there's nothing else for us to do with that. So you rather consider that as part of your decision making or not, but there's nothing for the clerk or staff to do with that petition.
Can we get staff to also go ahead and craft a change, what that change would look like, to Rebecca's point, to include commercial property owners as well as residential within said district? And so we could adopt that right when we did it. And then, to his point, stay it and get it up.
And, it almost sounds like we're going to say goodbye to this commission and start anew. Truly, I'm not in favor of that. But also, there were standards for choosing the people that we nominated them, and the board chose them. It involved, and this is in the introduction to the enabling ordinance, persons who have expertise and knowledge about architecture, about history, local history, who have a demonstrated interest in preservation and in I wish I had that right in front of me. Do you guys remember we wrote that?
Actually, it's state statute. So the
Yeah.
majority of the members of the commission shall have demonstrated special interest, experience, or education in history, architecture, archaeology, or related fields.
Okay, so that's one of the reasons why we hired this gentleman right here, because he cleared up a topic that we were going to spend a whole lot of time on that we're not supposed to spend a whole lot of time on. And that is the 196 number stands as it is, as I understand it, sir.
And
That's-
I think we have to deal in reality that this petition movement got started the minute people saw that first document. That first document no longer exists. So this is 196 people signing that they don't like that document. That document's gone. They don't have to worry about it.
If they want to come back, let's make it right on the record. They want to come back, withdraw their names, they should do that. They should let us know that. But right
Well,
now,
that's not even a city. It's not a city sanctioned anything. They don't have to do anything. It's that petition has nothing to do with the city.
And Alderman Carroll, you're absolutely correct that you can take that position. And I support you in you taking that position. However, I'm taking the position that I'm listening to 196 people out of 253 that says, please don't do this.
And I am too.
Okay.
No doubt. But it would be like me saying, if you don't like red, white, and blue signs and you sign that petition, go back and change it. We're not in that business. This is the table. We got the petition. We take it into consideration. Doesn't change Charles's comment about who has come to him and said what they said. And I think every single one of us got those same comments. So it just seems weird that we would be dealing with something in that context where someone has to go and change something from a third party to validate Charles's comments or my comments.
Can I ask this? Are you through with your questions, Mr. Mayor?
Yes, ma'am.
So in an effort to move forward, what you said is if we have specific things, Charles, I guess the question is, I know y'all have done the document and given it to us, but it seemed that you asked them to opine on whatever our changes were. That's in the form. Remember, you said we would make a list of whatever things.
Well, they
had.
asked us if we would be so kind as to document what we wanted to be changed. I clarified that to make sure that they were asking for us not to do it orally, but in writing. And as I understand it, that's what the board wanted us to do, is to put our thoughts into writing and give it to them. And then because then they would be able to say, well, that's not going to work because of this or this. Yes, this could work. We may be against it, but yes, it could work.
Can we commit to doing that in a timeline and be done? I mean, is there more? Does anybody else have any other questions? I think at this point, well, never mind.
Which is, I think we have a loose thread. Alderman Kelly had asked about what if we incorporate in a 15% or, some percentage of change to an existing building. Do we want to do that and have that trigger certain things? Am I stating that correctly? Okay.
I think that was.
And we just left that.
Write that in the suggestion box and let them bring it back to us. I mean, I have Brady's analysis of it, but if you still have that question, put that in the hopper.
Could you forward Brady's? Was it? Okay.
Same email.
Okay.
Stuff I asked about the 50.
Yes, so the state statute doesn't allow us to have an X percentage requirement or grandfathering provision. It has to apply all at the same time to everybody, versus a piecemeal approach like any other zoning district or overlay would be. So, why that would be a great idea. The state doesn't allow us to do that.
So then we're down to all or nothing.
Can we ask the state to change it?
Well, there's 105. Right, because it's a zoning question. I'm sure they'll modify that. And I just also want to say that there are 105 other communities in the state of North Carolina that have historic preservation commissions. 16 of them along the coast: Bath, Currituck, Southern Shores, Swansboro, Beaufort, Wallace. Curry Beach has a historic district. So, I mean, there's a whole litany of them. So this isn't a unique situation using the statutes and all that.
Well, as I got lectured last night, not by you, we're Southport, and we're going to only look at what Southport's going to do. So regardless of what anybody else in the world does, I'm not necessarily agreeing with that, but that's what I was lectured last night on. All right, so I would entertain a motion that would have a date on it, so we could put our thoughts together, forward it to the HPC for them to digest, review, tell us what they think, and we'll do the next step when we get there.
Can I just say this, Mayor? We meet the first Wednesday in November is our regular meeting. I don't plan to call any special workshops because we have spent enough time. This commission has met almost 60 times, sometimes 3-hour, 4-hour meetings discussing this. We're not calling any more special workshops. Now, y'all might replace me as the chairman, and if that's the case, I'm good with that. But as far as me being the chairman, I'm not calling any special workshops, but we'll meet again on the first Wednesday in November.
So that's the
fits
fifth.
in your time.
Could we do 2 weeks? If you got it by the 29th, would our board be okay with 2 weeks to get them the list?
That would be the 29th.
Yeah, I can get my stuff together in 2 weeks. Yeah.
If we got those to you on the 29th, you'd have them on the 5th. Did you say the 5th is your first meeting?
First Wednesday of November. Yes, ma'am.
Okay.
That is the 5th.
That works for me.
Alderman Spencer, your thoughts? Okay. All right, are you making a motion, ma'am? Uh-huh. All right, is there a second to that motion? There's a motion and a second. Is there any further conversation? Not hearing any. All in favor, please say aye. Any opposed? It's unanimous.
Excuse me,
I will
Mayor.
now,
I'm up here. Who's made the second? I'm sorry. Thank you.
sir, with your permission, I was going to entertain a motion to adjourn, but do you have something, ma'am? Go
Just
ahead.
a question. Do you intend to have another public hearing where the public can weigh in after we answer your?
I would. Right.
Okay, great.
Because it'll be an updated document.
All right, thank you.
I'd like to say thank you to the HPC. Very hardworking Historic Preservation Commission and very patient with our nitpicking.
And if I could just say, one time, our goals for historic preservation is preserve character, heritage, and landmarks, promote citizen outreach, promote and provide educational benefits of preservation. There's grants out there. There are tax breaks. and to prevent the loss of character and the loss of historically significant places. And I think I speak for this whole commission. Nobody started this process to become an enemy with anybody in Southport. I try to live by the good book, and I want my enemies to be at peace with me. And, but I love Southport, and you'll find out something from me. Anything I believe in, I'll fight to the very end. And I believe Southport's worth fighting for.
Yeah, well, I'm asking him first. Charles, are you good with the motion to adjourn?
Yes, sir. We can close the historic meeting out and then. So I'll entertain a motion to adjourn from the Historic Preservation Commission. We have a motion by Josh. Is there a second?
Second.
A second by Bonnie. Discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Yes, you may. And there's a second. And now, hold on, before you get up out of your chair, we still have to vote on it, okay? Any discussion? I just have one little discussion, and that is I wanted to get on the table and out into the open all of the concerns that people have brought to me. I think I've done that. The people then have an idea of where we all stand on different issues as of today. And I think that's all what my major concern was. And with that, all in favor of adjournment, please say aye. Any opposed? It's unanimous. We stand adjourned. Thank you, everybody.